Good afternoon, ladies and gentlemen. Welcome to BW Legal World's Saturday Solution segment, where we speak with experts on hot legal topics and latest legal developments. And today, we will be asking our experts on board to shed light on child custody laws in India with a view to understanding rights of single parents, non-custodial parents, maintenance for children in cases of judicial separation, divorce, and remarriage. To know more and to make this discussion fruitful, we are joined by Ms. Meghna Mishra, partner, Karanjawala and Company. Meghna heads the Delhi High Court in trial practice of the firm on the civil side and handles a wide range of matters, including family law matters, property disputes, commercial and corporate litigation, and arbitration. A very warm welcome, Meghna.
Thank you so much.
We also have with us Advocate Jayant Bhatt. Jayant holds dual Masters of Law from New York University, USA, and National University of Singapore. His office, Chamber of Jayant Bhatt, caters to varied clients comprising of governmental and non-governmental bodies, multinationals, financial institutions, and individuals on diverse matters. A very warm welcome to you, Jayant. We also have with us Dr. Rakesh Kapoor, co-founder Bamboo Tree Children's Foundation. He's also the co-author of Child Access and Custody Guidelines approved by 5 high courts and member of the Parental Alienation Study Group, which is a global consortium of mental health professionals that works with WHO on various initiatives. A very warm welcome to you, Dr. Kapoor.
Thank you so much, Ashima. It's such a pleasure to be here.
Thank you so much for joining us. And we have with us Ms. Deepika Narayan Bhardwaj. Deepika is an Indian journalist, documentary filmmaker, and a men's rights activist. Her documentary film, Martyrs of Marriage, about abuse of the IPC Section 498A, that looks after the anti-dowry laws and the abuse of it by brides and their families, received a global release on Netflix in 2018. So glad to have you, Deepika. Thank you for joining us.
Thank you so much, Ashima, for having me here.
And we also have with us my good friend Pragya Parijat Singh, Assistant Professor, OP Gentle University. She is an alumna of the Cambridge University and a former Supreme Court lawyer with a vast experience working at grassroots level with Human Rights Law Network. Welcome, Pragya. Thanks for joining us.
Thank you so much, Ashima.
I'm Ashima Ori, Managing Editor of BW Legal World, who has the honor of moderating this August session. Experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. Let's dive right into the conversation with our panelists. And, I gladly, the Bamboo Tree Foundation has shared with us some data which says 78% children have to wait for more than 6 months and 54% children have to wait for more than 1 year to meet with their own parent. Now, this is the time that it takes between filing of child access application and receiving the first interim order from the family courts. We'll do a round across the table and ask our panelists if this is a similar experience that they've come across in their practices or in the matters that they're dealing with. So we'll start with Dr. Kapoor on his experience and how this data came about.
Wonderful. No, thank you, Ashima. Thank you for having a seminar on something which is very seldom spoken about, that is rights of children of separated parents, which is becoming a huge area of concern. But so when we looked at it, our first starting point was to say that if we look at what evolutionary biologists tell us, we say that one of the reasons why humans dominate over planet Earth is because we practice dual parenthood. And that very concept is getting threatened by this whole family court system that we have today in India. Therefore, we went about doing a detailed survey of more than 500 parents and 60 legal professionals, which was even lawyers and judges from across India, right? So they came from small cities, big cities. They came from all the way down to Warangal to all the way to Bangalore, from everywhere. And the findings were actually very, very shocking for us. This was a very detailed survey, which we did, had about 72 different questions. And one of the findings that really came about, that forget even the parents, even the legal professionals are clearly stating that our family court system has failed our children. And that is for 90% of the legal professionals said that. Because what we are actually seeing is that 4 out of 5 children, that is 80%, 79% of the children who walk into the family courts, they actually crawl out in a way what we call as semi-orphan. By semi-orphan, we mean they lose not just one parent, they lose half their family, they lose half their roots, they lose half their value systems, and they actually grow up to be, as I would say, actually half the individual that they actually could be or can be, right? So these are some of the very worrying statistics which came up, and the reasons for this, of course, we've discussed it in great detail, which is there on our YouTube channel in the form of a video and with a commentary on the data. And that set us into the motion of thinking that what changes we could possibly look at, which obviously we'll discuss, but that's where we came about creating this data which came about.
Thank you, Dr. Kapoor, for setting the stage on that and sharing the data with us. We'll come to Meghna. Meghna, what has been your experience, and how do you think or these delays have extended over pandemic? Could you please shed some light on that?
Sure. You see, unfortunately, our system is adversarial, and so therefore every process is long drawn. That said, when I had started, coming to the profession, these matters and the family courts as such were non-existent. So a lot of work has actually gone into creating infrastructure, creating courts, getting people, counselors on board, and so to ensure that the welfare and our acts as they stand, the welfare of the child is paramount, and that's something that across I find all judgments and all benches, if you read the case law, that is what is paramount. But yes, there is no running away from the fact that there is delay, and in family matters of personal nature, you need much quicker system which must evolve. If whatever is required, if it needs more benches sitting, that needs to be done. Unfortunately, pandemic has made it much worse. My personal experience has been that even matters when they were filed, the first listing, Ashima, and that's really unfortunate, was a few months away. So that completely defeats the entire purpose. And it's not just about the custody, it's also about maintenance and welfare, about school fees being paid, and there are, many instances even now where women are not working or the man is not employed, maybe the woman's working, where maintenance is required and is an urgent relief that is needed. So on such matters, there is definitely a need that a quicker system is put in place. Uh, and we already, since we have worked on the infrastructure availability, perhaps what is just needed is to increase the number of these courts, because we are no longer in a situation where, initially, just to share, when I joined the profession, in a single court on a day, you would find one or two matrimonial disputes or, getting listed. Today, we have family courts across each district, several courts which are taking up these matters. So since the quantum has gone up drastically, we need to get the system augmented in terms of numbers so that the entire purpose doesn't get defeated and lost. Because today, unfortunately, when a client is coming to the court, we are, we have to tell them what is the ground reality. And the reality is, as Dr. Kapoor shared, that it could be months before any relief comes about, whether that is visitation or any other. So
Thanks,
that would be my opening.
Yeah, thank you, Meghna. Thank you so much. Unfortunately, yes, the delays are, putting us and the children at stake. But Jen, coming to you, what has been your experience with the delays and any success on matters after the pandemic as courts open up?
Right. So, Meghna, first thing first, India, since last March 2020, since we have witnessed lockdown, COVID wave 1 and 2, practically no trial has been conducted in the courts. We have been getting on block adjournments. And unfortunately, whenever I address a webinar or my young students and young audience, I tell them that it's been 1.5 years since I have not practiced trial in the trial court, and that's very unfortunate. So for that, I don't think the family courts or the courts are to be blamed. I think the nature of pandemic is such that it has taken the world by the storm. So we have to first stop blaming the courts only for this. As my predecessor speakers rightly pointed out, the whole concept of setting up family law is to look after the welfare of children and also to ensure that the parents who are fighting or the families rather, which are fighting with each other in an Indian setup, especially, should be taken care of. Just to bring the point home, let me narrate a Urdu couplet, and I'll pause it there because there are other speakers as well, which says, "वो खैरियत पूछें तो हैरत में ना पड़ जाना, वो खैरियत पूछें तो हैरत में ना पड़ जाना, परेशान करने वाले कभी अपने भी होते हैं." So, in family law disputes, there are family members who are fighting with each other. It's not an alien component which is bringing an element of dispute to court. And that is something I think we need to focus on. And the courts have already devised a mechanism of conciliation. There are mediations, there are pre-litigation mediation and post-litigation mediation happening. Obviously, there are multiple litigation disputes which are enumerated in multiple laws, across different statutes in the country. So I think we are in good place. But then again, I think all said and done, the nature of our judiciary falls in the hand of Parliament in terms of funding is concerned, so that we can have more courtrooms and more judges to take care of the building pressure on the judiciary.
Thank you, Jayant. Very well put. We are fighting family. It's not easy. Deepika, coming to you, what has been your experience? And we often talk about how this impacts children and women, but I'm sure you have more insights on how this impacts the men as well. So please, would you shed some light on that?
Yes, Ashima, unlike all my co-panelists, I come from a very personal experience of dealing with men who are undergoing separation with their wives. And in a lot of cases, kids are involved. And I have had very, very, heart-wrenching experiences where a father has not been able to see his child for months and months, sometimes years. And I think before pandemic also, it's not just pandemic, before pandemic also. For years, I've been now talking to fathers who have been separated from their kids. And honestly, getting visitation is also a struggle. Custody is a distant dream altogether. And unfortunately, if I may actually say this, it is said that welfare of child is kept on priority. But in my experience, or from all the men who have come to me and spoken about their experiences, I think the judges tend to be largely biased towards the mother, no matter how good the father has been in the upbringing of the child. So even for visitation, and now during pandemic, we have had virtual hearings and everything has gone virtual. But I know of fathers who have waited for months and months to just get, half an hour conversation with the child. And the worst thing is that even when you get this access, the entire control is so much in the hands of mother. And I really apologize for making my experience or the sharing one-sided, but it is because of the kind of people I deal with. I usually, deal with a lot of men who are victims of the legal system. So there are months after months they first get visitation, and then when they're also having a conversation, the control is entirely in the hands of the mother. So she could say, Wi-Fi is not working. She could say the child does not want to speak. So there is a lot of helplessness that I see, and amongst fathers particularly, and they just don't know what to do about it. And I've seen them suffering for months and years, just somebody has not seen their kid for months, somebody has not seen their kid for years. And that's why I say, if we keep the welfare of child as a priority, then I think it's very important for judges at least to have a small little conversation with the child as well, on what does the child want, what's the bond of the child with both the parents has been. And my submission honestly is, whether the non-custodial parent is a father or a mother, I think both parents deserve to be in the life of their child. And I think that should be the major priority.
Thanks, Deepika. That's true. Any non-custodial parent would go through, some of those difficulties. And it's unfortunate that it so happens that, yes, sometimes, men receive the shorter end of the stick when it comes to matters of child custody. Pragya, coming to you, what has been your experience? Also, it's not just about the gender. It sometimes also evolves around how financially sound the parents are, or one of the parents is, who will probably be given the custody. Now, in these matters, what has been your experience? We'll start there and then we'll do another round of asking everyone about the tips.
Okay. So see, Mr. Anonymous once said that the worst type of animosity is the one between the husband and wife. And unfortunately, the one who's at the receiving end is the kid. And also they say that family courts are the one where worst can be seen in the best people. So, worst emotions are displayed by the best people. So courts are the places where I have personally encountered different type of emotions in distinct cases. So to say that one case fits all would not be correct. Regarding the idea that welfare of the child is paramount, absolutely. So this is where the parents patriae jurisdiction of the court comes into foreplay, or state for that matter. So state assumes on itself the duty to take care of the child. Honestly speaking, how things have developed over the period of time, just like Meghna ma'am has said that initially when these courts were set up, there were hardly 2-3 cases listed up each day. But now if you see, there are like 40-50 cases listed up every day. So we do have short-term plans and long-term plans. My personal experience per se when it comes to finances is definitely that the first challenge for the parent who's not financially well off is that mental angle that they don't have money. If they're not able to take care of the child, I'm sure that the opposite party is going to take advantage of that, and they are going to. So there are a lot of misnomers also around this idea, due to which they do not even approach the court, and they're ready to carry on with this violence. They're ready to jailify all sort of these things which they shouldn't, just because of that inherent fear that they might lose their child because they are not financially well off. However, the law is very clear, and we do have certain landmark judgments, just like Ubale versus Ubale. And then in 2015, we also had this Law Commission's detailed report, which categorically mentioned that in India, we do not really recognize the idea of joint parenting. So it's, at the end of the day, we tend to give visitation right to somebody and custody to somebody. But in India, we are now treading towards a direction where co-parenting is also evolving. And at the same time, there are certain landmark judgments which clearly say that even if a mother or a father is not financially well off, it doesn't mean that the child, that they will be bereft of the custody of the child. And at the same time, we need to see that these personal laws are very conflicting in nature. They are definitely gender biased. However, we also at the same time have this Guardianship Act, which is very secular in nature. And it's very clear in certain landmark judgments that by any chance, personal law is not supposed to supersede a neutral law. So yes, welfare of the child is paramount, and the judges are walking on a very they're literally treading, and they have to maintain that sort of balance. And personally, I've encountered that they do interact with the child. They know that the kids can be tutored, so they call them inside their chambers. They ask them all sort of questions, good and bad. They have counselors along with them. So yes, we are moving in a better direction. So outrightly saying that nothing is happening would not really be correct. But yes, betterment is still on the way, and there's a lot of scope to do better about it.
Thanks, Pragya. A good point mentioned there on shared parenting. I also see a lot of our attendees, echoing the same sentiment and asking why shared parenting is not a concept in India. Before we go there, we will come to understanding the sort of, avenues that we have for people wanting to separate. So Meghna, coming to you, we've had this discussion before, but in light of child custody, again, could we know from you that parents wanting to separate, what is going to be, the status of children when it comes to judicial separation, divorce, and remarriage? We'll just take an overview first, and then we'll delve into the nitty-gritties of it.
Sure. So broadly, a judicial separation is suggested in scenarios where there may be some hope of a reconciliation over a period of time. Whereas divorce would be, once done, there is no going back unless you remarry the same person. So in terms of distinction with regard to children, and like I said, and I want to just repeat this, and I know Deepika said that she's interacted with people who've had unfortunate instances of not having had visitation for a long period of time, but that is really not the norm. And courts do call, like Pragya mentioned, the children to the court and they ask. So while when the child is an infant, the thumb rule really is up to 5, 6, or even I would say 7 years. The child is normally because the thinking behind this Ashima was that the welfare would be with the mother. That said, in today's scenario, a lot of fathers are the primary caregivers after the initial, infant stage. So, and you do find, especially in the bigger cities, that men are coming forward doing household chores and being taking care of the children. So it really depends on each case and it would depend on the facts. And that's where the child being called, and typically in Delhi, after about 7 years, or even sometimes where a request is made that the estranged parent who doesn't have access or visitation can come to the court and say that while we were together, I did have a good relationship. And the sooner you get to the court to start asserting that is better, because if especially in scenarios, Ashma, where the child is younger, there the difficulty is, they don't have a very long memory. So whereas when after about 8, 9 years, it's much easier because you can talk to them on the phone, or they also start becoming a little more assertive. But when the child is that young, then definitely those are issues because they also don't have the ability to go to the court and say, I want to meet my father. But yes, the delays are there. So as far as judicial separation and divorce are concerned, that the only real difference is just in the marital status of the parent. Maintenance is something that you need to do. You need to maintain your children, and that needs to, in fact, there's a recent judgment of the Supreme Court which clarifies that even if the spouse remarries, the father will continue to take care of the child. And interestingly, if I can share, there's a judgment of another court which frowns upon a mother agreeing to waive off or give away, stop the maintenance for the child, because the entire statute and thinking is that what is paramount always has to be what is good for the child. And no court is likely to say, and doesn't say in my experience, that no, don't give visitation. In fact, during COVID times, I found our Delhi High Court has said that if you can't meet physically, you ensure that people are meeting over Zoom type of platforms, and take it virtually to ensure that there is some continuity of that relationship. So there are ways that you can work this out. Sometimes one has seen, this is pre-pandemic, I'm saying, spouses have been called to the court chamber, the court itself facilitates the meeting. Sometimes where parties are fighting very aggressively, and in the unfortunate scenario that they are even apprehensive about not handing over the child in a public place, I have seen that they have been called to the court. The court has given the child, said that come back at so and so time, hand over in my presence. So there is all this effort that is being made. But of course, there will be always instances of people misusing the law, of people who somehow are not able to bring forth their representation in a correct way to the court. But I think our act does provide for enough, and our courts are very keen to ensure that both parents have access, have visitation, and welfare is kept paramount. That would be my experience.
Thank you, Meghna. So just to put it out there for our audiences, that whether it is judicial separation, divorce, or remarriage, you can, and there is recourse to legal, taking legal custody of your children, and the same would have to be maintained by the other parent. Having said that, we come to Dr. Kapoor. We mentioned, how children are being asked by the judges about, what's the best interest of the child, and you would have more to say on that, Dr. Kapoor, that how would you, want the courts to really be asking these questions, how to reach a decision when it comes to speaking to such impressionable minds about their other parent, and getting a definitive answer from them that yes, I want to be with my mother or my father, and why not.
Right. There is a beautiful saying which goes, children must have a voice, but they must not have a choice. Right? So what I'm going to do is, because, see, I'm a little, a little concerned with the discussion that has had so far of we thinking about the issues as something which happens at the extreme, and the courts are doing a great job, right? At the cost of, or at the risk of really, let me take you through actually a typical case which happens in 80%. And that would tell you that today, as a norm, children are being abused, right? So let's just start with, let's say a non-custodial parent files a certain case under Guardians and Wards Act. It takes on an average 9 to 14 months before that person, whom let's call him the non-custodial parent gets any access to the child. Now let's look at it. I don't know if all of you remember that and this is 9 to 14 months, more than a year, just a year back during Trump's presidency, the refugee children were not allowed or were separated from their parents, and there were riots across the country because, as a child-friendly country, they realize just separating between for 3 to 6 months also causes not just behavioral changes, it causes epigenetic changes, which are changes in DNA, which are passed on to the next generation. Now, let's say even if that person has got the visitation order, I hate the word visitation, but I'm saying visitation order. What is the average amount of visitation do you think they get? They get between 14 to 18 hours per month. And my legal panelists will tell you that is no more than what jailed convicts get. So what we are talking about is the fathers or the mothers, the non-custodial parent is relegated to be like a jailed convict in the life of a parent, in the life of the child. Now let's say, does this parent even get access to telephone during vacations, school, medical information? Less than 10% of orders are such. Therefore, this is the norm. We keep discussing and we keep, moving on the sidelines saying, oh, these are rare cases, these are extreme cases. No, these are not extreme cases. This is the reality of our judicial family court system. Now comes the more important part. The person has got such minimal orders. What amount of these orders actually get complied with? Less than 1/3. 2/3 of the orders, 67, there is blatant contempt and violation of the orders. Let's say what is even more worrying for me is what happens after that. What is the response of the judiciary? In 95% of the cases, there is zero response. That means they ignore it completely. Now that that has been ignored, now what happens? During this time, contempt applications, other applications come in, and a period of about 2.5 years typically have passed by before the father or the mother or the child, non-custodial parent and the child, get to meet each other. Let's say now they've got to meet. During this time comes what I call as the elephant in the room, or the worst form, which a lot of us think as, oh, it's tutoring, brainwashing, what is known as parental alienation, right? Parental alienation is not a husband-wife feud. It is a recognized form of severe child abuse, which leads to, and this is coming from scientific research, which leads to outcomes worse than sexual abuse of children. These children have their lifespan cut short, life expectancy cut short by 20 years. Parental alienation is no different than murder by slow poisoning, right? Now, the judge typically calls the child to the court for, let's say there is an interview. Let me first remind all my legal panelists, I'm sorry, I'm not a lawyer, so I don't wish to tread on your territory. Section 7(1) of the Juvenile Justice Act clearly states no child should ever be called or exposed to a premises which even resemble a court. Are we saying that our children of separated parents, I have to help. I feel angry. I'm sorry to actually say that. Does one even realize the trauma that is going on in a child's mind when they're asking them, oh, who do you want to live with, the mother or the father? That's like asking a child, how about if I ask the panelists here, do you want your right hand or your left hand? I'm going to take one away from you. That is not how children, and what is the amount of time typically that these judges spend with their children, with the child, to find out what is known as the voice of the child, right? And these are all, what I'm giving you figures are all documented survey findings and coming from huge. So they spend typically 14 to 15 minutes with the child. It takes, and this is, I'm speaking for my community, it takes even the most trained child psychiatrist 45-minute sessions, 2 to 3 of them, to just bond with the child. And we expect our overburdened judges in 15 minutes to be able to elicit the voice of the child. How is that possible? Now, typically this happens and the child is absolutely. So once the child comes to the court for these kind of child interviews, what happens? The child says, I don't want to meet with this parent, right? Because it's 2.5, 3 years have passed by. And then what happens? Now that the child has been told that he refuses to meet with, the judges and both the non-custodial parents give up. And we've heard, lastly, I would just like to say, we talk a lot about COVID orphans which are there. In the last 2 years, the number of COVID semi-orphans or half orphans that we've created, because there were at least 2 PILs in the Supreme Court saying at least allow them virtual interaction. No such order. And it's not as if that, this is something unique in India. Countries like UK, US passed orders saying, because they realize the importance of both parents in a child's life. They passed orders during COVID exempting all parents traveling for meeting their parents. They said the lockdown does not impact them. They must go and meet their children. Because we all realize, I think we in our media channels and everywhere, we talk a lot about the problem of COVID is, of course, the physical illness, which is there, right? But what we call as the long COVID, the mental impact on these children of not going to school, of not being able to meet with their parent, we actually are creating a mentally dysfunctional society. So therefore, lastly, sorry for the long monologue, but I would just like to say, this is not something that we are talking about that's happening on the extreme. There is certified child abuse happening on a daily basis, and we are completely turning a blind eye to it.
Thank you, Dr. Kapoor. Some really disturbing stats and insights there. Jan, coming to you, Dr. Kapoor mentioned how there is a violation of these orders, and correct me if I'm wrong. That the logic usually that the law's logic is not to disturb the settled, and even in cases of illegal custody, sometimes when there's violation of orders and the say the custody is given to the mother, but the father will take away the kid under the pretext of just going out, and then will make sure that the mother never sees the kid again. And these are cases that happen, and vice versa, can be true for any gender. Now, what happens in that scenario? Could we hear more from you on the legal perspective?
Right. So Ashima, look, the first thing that we need to understand is we don't need to go hammer and tongs against the system. Not because I speak as an officer of the court or I don't see the fallacy or the pitfalls that there are in our system. But please understand that people come to court because they either need relief or they need justice. Now the judges or the lawyers do not tell families to fight. We don't tell people to get married. We don't tell people to get divorced either. There is a mechanism. You have the law of the land. You are free to exercise that law of the land. It's not just true for any family matter. It's true for any contractual, constitutional, criminal, or whatever matter which may come to the fore. So I'm not going to hang the judiciary without a fair trial. That is number one. Number two, so far as a parental dispute is concerned, both national and international level, because I represent both clients from within the country and from NRIs or foreign nationals, and both mothers and fathers. So it's a very general answer I'm going to give you. Now, there are cases where the matrimony has had such a bitter spat between the parents, either in a nationalistic scenario or in an international scenario, that one of the parents tend to take the child away. So normally in an American setup, for some of the American clients that I've represented in India, in America you have this whole concept of being an absconder. So the term absconder is attached to a parent, where in India we don't use such terms. However, within our Indian scenario, if such things have happened, a parent is free to file a habeas corpus writ petition in a court of law, which is normally the high courts of the country, or should the need arise, then go to the Supreme Court for as a matter of appeal. Now, should that happen, by and large, the judges time and again have taken this overview that look, even if you are trying to exercise a habeas corpus petition, we cannot term a parent as an absconder. One, because they are not criminal by nature, they are a parent. So yes, what they did was perhaps wrong, depending on facts and situation of a particular case in a given scenario, but that does not make a parent criminal. For example, people in a very, very bitter matrimonial disputes across the globe can also use Interpol or their own local police, the Federal Investigation Bureau or the Scotland Yard, etc., to even have red corner notices for each other, for the time. Even in India, we have something called a lookout circular or LOC, which you can obtain from the magistrate court or the criminal court in India, where in a very bitter matrimonial dispute, people are just going after each other. And I'm not saying that we as lawyers are to be blamed. We are, at the end of the day, the mouthpiece for clients. And if they want us to execute something for them, we have to, we tell them the pitfalls. We also try to counsel them. It's not that we are not counseling our clients when they come to us, or the judges are failing in their duty when they are trying to counsel people. But please understand, as a lawyer who is practicing in a court and as a judge who is seeing these at least 50 to 100 odd matters on a daily basis, is very well versed with the process of the legality and what goes in and out of a family system. One, because by and large judges are very experienced, with at least 30, 40 years of experience under their belt. Lawyers who are practicing in court at least a good 10, 20 years of practice under their belt before they take a seasoned client and are representing them. And we all have our own families at the end of the day. We know how a family setup works. It's not rocket science, raising a child. It's not rocket science getting into a matrimony and getting divorced. These are human matters at the end of the day. So yes, do we need a specialist? Absolutely. I'm not against having a specialist. But people need to understand that in a court of law, your emotions have one place and the legality has to be read as per the law of a particular country, and the law keeps evolving. There are laws which may be turned as bad law 5, 10 years down the line. Maybe so. For that, somebody has to challenge a particular order before the court. So it's not that the judicial system or the lawyers are not doing anything. On the contrary, I would say the way the family law jurisprudence has evolved in this country, at least in the last 5 to 7 years, has been phenomenal. The whole concept of parens patriae, which is that a court has to come as a welfare guardian of a child. The court has to step into the shoes of a parent if one of the parent is erring in their duty, has really been read into a lot of judgments in our country. So I think the courts have been have taken the bull by the horns, if I may say so, and have been very, very active in terms of even warning the errant parents, telling them, look, we can see right through you as to your conduct. If you are not paying maintenance to a child, if the maintenance is awarded by them, and we already have a concept of contempt of court. So if a parent, despite an order being given either to a mother or to a father in terms of maintenance, in terms of visitation, in terms of custody, in terms of meeting rights, in terms of relief being given to the grandparents, in case of non-compliance, can always file a contempt petition, and they are taken very, very seriously by the courts, be it a district court, be it a high court, be it a Supreme Court. And off and on, you would have also read in so many news articles or news channels that courts have reprimanded these erring parties. So I don't think the courts are erring. People still abide by the court order because they have the fear of law, because otherwise they'll be sent to jail. It's as simple as that. Look, no judge or no court or no lawyer in the country said, go divorce your child. Parents get divorced because they get married, but you cannot divorce a child. The jurisprudence has evolved in the country that once a parent, always a parent. And as Meghna ji also rightly pointed out, that even Supreme Court and other high courts have followed suit, that despite the fact that you may remarry, despite the fact that you may remarry 100 times, doesn't matter, till the time a child attains 18 years of age or an adulthood as per the Indian law, you have to take care of their upbringing, their education, their basic care and concern. Those things have to be taken care of. And in so many maintenance matters in my chamber, I have seen, if any party is erring, we file execution petitions, we file contempt of court. So the law is in place. Just that, as I said in my opening comments in the first round, that we need more judicial funding for more courts and more judges, because we have a very poor judge to population ratio. But that does not in any way translate that the judges and the lawyers are not performing their duties.
Thank you, Chant, for putting out the letter and spirit of law being in place and at the, there to help the people and parents. I see a lot of questions and statements coming from all our attendees. I would just request them very quickly that if you have any specific questions, would you please, send them in our Q&A section, and we'll take it up shortly with our panelists. So requesting all of your statements to be converted into questions into the Q&A section. In the meantime, I'll come to Deepika. Deepika, we heard about a lot of judgments and maintenance, how the courts have directed fathers to maintain their children until they attain majority. There's also a recent Supreme Court judgment that says that liability and responsibility of a father to maintain the child continues to the age of majority despite resolution of marriage of the parents. Now, what has been your experience with fathers having to maintain, have they wanted to not maintain their children, or have they wanted the mothers to maintain the children? We'd like to know some of your experiences as well. Could I request you to unmute, please?
Yeah. I'm sorry. Ashima, in my experience, yes, I try to remain very balanced whenever I share things. I've seen a lot of fathers absolutely willing to pay maintenance, absolutely maintenance, not just for the child ke liye, so they want to do everything that they can do on this planet Earth, but they are very bruised inside because they're not able to see their kid. So I have seen some cases in which fathers have not given maintenance and they say, मुझे मेरे बच्चे को भी नहीं देखने दिया जा रहा, तो मैं क्या maintain करूँगा, है ना? So somewhere they are wrong, somewhere they are also not wrong. And I would humbly like to completely disagree with Mr. Jayant. We have seen n number of men going to jail for not paying maintenance to their wife. I would like to ask Jayant sir, has he ever seen a woman being sent to jail for not showing the kid to the father? मेरी knowledge में, मेरे को 9 साल हो गए इस field में, I have not seen a single mother being even fined probably 500 rupees, rare instance I think I have heard, but except that, reprimanding probably, that's also I have not seen much. But I have not seen courts coming down heavily on a mother if she brainwashes the child, completely tutors the child, and completely tries to alienate the child. So that's one thing. And sorry to bring this up, but this has really pained me. Just 2 days back, there's a father who was in Kanpur. He was undergoing this separation from his wife and all that. A 6-year-old girl. So I'm assuming if there was a judge who would have asked the girl, about when you're talking about welfare of the child, probably the child would have shared. And there were such cute pictures that came out in the newspaper also showing the bond between the father and the child. This man committed suicide because he was not able to see his daughter, and he was not. And this is just not one case. I've had so many men come to me completely suicidal क्योंकि वो अपने बच्चों से नहीं मिल पाते हैं, उनको देख नहीं पाते हैं. I do not have a child. I cannot even imagine that trauma, but I have a niece. And if someone was to tell me that I will not be able to see my niece for 1 month, 2 months, वैसे वो अलग रह रही है तो मुझे कोई दिक्कत नहीं है if she's staying far. But if I'm being forced to not see her when I want to see her, I think that's a great pain. So that's one thing. I have also met kids sometimes when the fathers had the visitation, and I asked them, how do you feel about this whole thing? I've had kids telling me that we feel very broken. We feel we are asked to choose it, which we completely feel very wrong about. And it's not just about custodial issues. I was in a space on Twitter a few days back where I had he's 20-year-old now, but he has been seeing his father and mother litigating for the last 10, 12 years. And he was begging. This child was begging us that please do something. Nobody wants to know what we are going through when our parents fight like that. But I would agree with Jayant sir that neither the courts nor the lawyers, nobody asks these people to fight. They fight by themselves. So that's where my last submission is. One, I think the Women and Child Development Ministry needs to really focus on this aspect. I do not see much intervention by the WCD ministry on this. We have now, like Meghna ma'am said in the beginning, earlier there used to be 1-2 cases. We have humongous litigations going on in the family courts now. Kids are involved in a lot of these disputes. I think the Women and Child Development Ministry really need to conduct a thorough research, interviewing some of these kids, separated parents, on what are the best practices that need to be taken care of or need to be followed by the courts. I would really love to applaud Karnataka High Court, because they have taken shared parenting in a big way. They have passed, I think, 5 or 6 judgments now emphasizing on the merits of shared parenting. So I think if we can have a research done on a ministerial level, and then we have some guidelines by the Supreme Court or by the ministry, then I think the courts across the country would be able to follow them in a much better way. My last submission is I know a friend who is in Gurgaon, he's in advertising. He and his wife went through a bitter divorce. It was not easy. They have a girl and they have been co-parenting the kid. They have not let the wrath of their broken relationship come on the kid. They mutually decide the kid goes and stays with the father also. The kid goes and stays with the mother also. They may be fighting like animals in the background, but in front of their child, they are the best people possible. And so I think it's, of course, there is problem in the judiciary. Of course, there is some problem in the laws and the way they are implemented. I would say there are written statutes to take care of everything. But अगर वो written statutes को उसी zest और spirit में follow किया जाता, तो मेरे ख्याल से इतने सारे लोग इतनी justice की आवाज नहीं उठा रहे होते. So what I'm saying is we have all of those things in place, but at the end of the day, we also have a responsibility to be better human beings. Mothers have responsibility to be better mothers. Fathers have responsibility to be better fathers. And much more than that, I think everybody has better, responsibility to be a good parent. So I think, like you initiated the question about marriage, divorce, and judicial separation and all of that, whatever arrangement it is, I think it's not very tough to keep your fights and bitterness aside and let the child have best of both the parents. No judge can implement that. No lawyer can get that right in place. I think it's only 2 people who can get that right in place. So a lot of responsibility lies on these men and women as well. Yeah.
Thank you, Deepika. I think fair points there. And I think that's what we want our audiences to know from this discussion, that, whether you are fighting with each other you're in an acrimonious relationship, in a bitter relationship with each other, please consider the plight of the non-custodial parent. Try to reach an arrangement between yourselves. If not, here's a discussion to help you figure out what are the various ways in which this can be done. Jayant, before I go to Pragya, Jayant, coming to you briefly on the points that Deepika made about mothers never receiving a harsh, sort of punishment when they are at fault, when it comes to getting the children or the fathers to meet. Your quick comment on that.
No, I think that's a very valid point that Deepika ji has raised, and a quick rebuttal to that point. Number one, as I mentioned, the cases of habeas corpus, there are a number of judgments available from various high courts across the country, where the cases where the mother, especially in international scenario and being of Indian origin or holding Indian passport, has run away from a particular jurisdiction or within the country, the custody has also been awarded to fathers. Having taken the child away, even a minor child away from fathers, there are multiple judgments available. I can email it to you, Deepika ji, later after the session. She can have a look at them, number one. Number two, look, every case is very fact independent. So you have to look at a case from a fact point of view. And I'll tell you from my example. 8 years ago, I was in Tisari, and there was an old client of my senior back then when I was still a junior in a chamber. He was arrested in an FIR, and the lady was left with the child. And she was also subsequently arrested in a criminal matter. So she was brought at about 4 in the evening before the Metropolitan Magistrate, and she was to be sent to Tihar. At that very moment, with just having a pen and paper in my hand, I wrote a bail application. And for the first time in my career, and perhaps the last to date since I practiced, the magistrate on the spot granted her bail order. Why? Not because she was a mother, but there was nobody in her family to take care of the child. Should she also be sent to jail? because her husband is already in jail. So as I said, facts have to be sifted once the judge has to give a judgment. So it's not that that the courts do not come down heavily on women or only on men. I think that's a misnomer. And anybody, I welcome my panelists who are not practicing lawyers to come to family courts at least for 1 week continuously and watch all the matters, and they will see that it's not a automatic mode of giving judgments or orders in every case. Judges see every case, every file properly. Yes, there are delays. I'm not defending the delays in court system, but I'm saying that judges have to apply the judicial mind to every case, because every fact is different. There are cases where there may be case of remarriage. There is a case where there may be no ward. There may be cases where there may be children or stepchildren involved. So every case is different, and we cannot put a blanket comment on judiciary that they are not doing their duty properly. So I think that's a misnomer. That's the only thing I wanted to point out. And yes, as I said, the laws are already in place, and there are judgments which go in favor of both the genders. And in my own practice, as I told you, I represent both husbands and wives, and we counsel them. And as lawyers, we know when a mother is right or when a father is wrong, or when a father is right or a mother is wrong. So there is no black and white. Sometimes there are a lot of gray areas involved, especially in Indian scenario where there are extended families involved, where there are grandparents involved, where there are emotions involved. I have seen people even slapping each other right out of the courtroom. So sometimes we have to abate those fights. So people have a lot of angst, as I said, against each other, which then percolates to to the judges and lawyers, and then we get the bad name for getting a failed marriage, which parties failed themselves.
Thank you, Jen.
Ashima, just quickly, I'm not going to make it very long, but just few things. Jen, sir, I'm sure you would know this. We are not a signatory to the Hague Treaty, so I just want to bring in one more aspect. Since he spoke about international disputes, I am in touch with a lot of fathers and a mother as well. Jahan pe it's a case that one of the parents ran away with the kid, and overwhelmingly it is more mothers who have come to India. And there was a law commission, there was an entire committee sat on that and to discuss on whether we should be signatory to Hague or not. So all of these cases which I'm talking about here, they have been fighting for years and years. In fact, one of the families right now here in India to actually meet their ward, because they have to fly again and again just to spend some 1 or 2 days with the kid. And even though the kid was really, really attached to the father, the court did not pay any heed. And the father has been coming to India to have some sort of a semblance of being in relationship with his kid, and he flies down every time. So I'm not too sure international in how many cases, but I'm sure, sir, if you're saying there would be cases, but international parental child abduction is also an issue. I just wanted to let their voice be heard, because I see so many comments also by people who are living abroad. Their kids have been taken to India, and the courts, from whatever I have, all the people who have come and shared their experiences with me, it's not very easy to take a child out of India if one of the parent has brought the kid to India. Maybe my experience is limited to the people who I interact with, but that's been my experience. And that's a fact that we are not signatory to the Hague.
Thank you, Deepika. Jen, before I come back to you on any other comments to this, I think a lot of people have sent us questions. So we'll take that up, and requesting panelists to spare, some 10-15 minutes over one, if that's possible, so that we're able to take all these questions from our attendees. Pragya, I'll come to you
Ashima, may I just interject in just one small thing I wanted to mention?
Yeah,
right?
Sure.
This question of each case being from fact to fact based, I think we blow it out of proportion. Truthfully, 80% of the cases are exactly the same. And that is what our survey has found out. Sure, 20% of the cases, there may be certain differences and things like that. But my real question is, in those 80% of the cases, we've actually studied the orders. Like Deepika mentioned, in this thing, there are probably 4 or 5 orders of shared parenting. There are 2 orders in this entire country where parental alienation has made any difference, right? As I simply say, we can have these amazing 5-10 orders, but that constitutes less than 0.1% of the population actually fighting. So the 99% of the people have this problem, and yet we go on quoting those 1% orders and start saying, oh yes, our justice system is doing a great job. That's all I want to say.
Thank you, Dr. Kapoor. We hear everyone's sentiments here, and of course, in your varied experiences, all of this is certainly, disturbing to know that how things are really happening on the ground, even though there is law to protect the rights of parents and children. Let's hear it from our attendees, their queries. And in our closing comments, let's look at how we can how the jurisprudence on this needs to evolve, or how things can be done better. Before we go there, Pragya, coming to you with one of the questions, I'm just reading it out. This is for you, but I'll read, there's a part of the question which is also for Dr. Kapoor. So I'll start with the whole question. India is not ready for shared parenting. My question to Dr. Kapoor, what are your organizational plans to break this mindset? Dr. Kapoor will come back to this later, but there's a question for Pragya. Which law says India is not ready for shared parenting?
So we don't have a settled jurisprudence per se, or we don't have any particular section that says that we need to have shared parenting. However, the usual trend in the courts is that we end up giving the custody or the guardianship to one of the parents. So we are moving towards the direction where it is now believed that it would be better if both the parents see. It's not a pick and choose scenario. So it is definitely advisable, and even courts take it seriously, that it would be nicer if we give a co-parenting rights to both the. So one of its own kinds, a type of a case that I did in 2017 in Karkaduma court. It was a ugly spat between the husband and wife, and I might not really be able to say yes to what Dr. Kapoor is saying, that 80% of the cases are alike. Facts are very different in each and every case, and even if in toto it might look that it is a spat between the husband and wife, but the matters that the factual case, the factual scenario is so different, so unique in its own sense, that when you apply it in totality over that particular case, a judge has to take a different direction in those particular matters. So on that basis, we don't have any particular law that prohibits that co-parenting should not be done. We are moving towards that direction. As on date, we don't have any particular section that says that yes, co-parenting needs to be done. But at the same time, I was discussing about this case that I did in Karkaduma court. So the judge said that since the situation is very complicated between the husband and wife, I would really want the counsels for both the parties to prepare a parenting plan. I'm going to analyze it properly. You have to take care of 3-4 parameters, how to provide good education to the kid, ethical upbringing, this economic well-being of the child. And once you prepare all these things, then you come to us. So this was one of its own kind, and I was really amazed that even at a trial stage, a court is cognizant of the fact that this is something which is very important before reaching a conclusion. So rather than making this child custody a gender issue, I think it would be really wrong to say that if we are narrowing it down to a men versus women issue, it would not really be correct, because I have clients where I have represented interests of both men and women, and it's not really fair to say that one of the parent is always at the receiving end, and it's very painful, it's very traumatic to see parents fighting, bickering over bad things, and the child has to go through all these things. So the idea is that now we should move in the direction where it's not easy to forget what is there between the husband and wife, but at the same time, it's not about the ego. You have brought a new child, you've brought a new life to this, you've brought a new person to this planet. So at least the least you can do is to be respectful enough to forget your differences and be kind enough to this person. And henceforth, I believe that counseling, providing counselors, psychologists, and a panel of people who will help a judge, all these things cumulatively will really help deciding the future of the child in a better manner.
Thank you, Pragya, for sharing those reforms with us, how we can move forward. There's another question and request Jen to take this up, please. This is from David Anthony. Hello, sir. My ex-wife has taken my son to USA along with her, and she's working there. I have filed GOP here to at least get a visit. She's threatening not returning to India. What can I do here in India to see my son?
So lot many questions, by the panelist. I think, look, I'll have to see what juncture of case, or what are the cases that you have filed. Were there any cases that you previously filed in India against which she has, flew to US? Is she an American citizen? Is she an Indian citizen? There are multiple facts, as Pragya ji also pointed out, that we have to look before I can give you, any advice or any opinion. But habeas corpus, as I said, please file habeas corpus if you haven't, wherever, which city or which state you are in, contact a lawyer there and ask them to file a habeas corpus. It's very powerful. Amongst the embassies, also people coordinate once a habeas corpus is filed, or once a child is even taken abroad, to other nations. This is one of the best rates, especially if the child is Indian citizen and born on Indian soil. If the child is also a foreign citizen, then you'll have to initiate proceedings in America and engage a local attorney there.
All right. So you said that the embassies can also be engaged in this matter to
for official communications, to convey the court orders. Yeah.
Yes, and just in case if the marriage has taken place in India and the parents have once at a point in time resided here and the citizenship of the child is also Indian, then you can also obtain a ex parte ad interim order from the court wherever the matrimonial house was or wherever the marriage took place.
So Pragya, just to break it down for the common viewers, what exactly would this mean?
So since I am not really apprised with the facts of this particular case, but definitely ex parte orders is without hearing the opposite party. So if there is an exigency where one of the parent is claiming that without my knowledge, I'm not really aware of the facts.
Yes, hypothetically.
Yes, so hypothetically, if this is the scenario, then the husband can obtain a ad interim injunction order against the opposite party, that is the spouse, that this person should be, without even hearing, on the very first date itself, notice should be issued that an injunction order should be taken against that person from not doing something or to come back to India. So that's the scenario. But then there is a lot of other complexities involved, whether that kid is a foreign citizen, so on and so forth. So these two other options are there. But in case, I think best idea is to move a petition of habeas corpus in your respective state high court concerned, and you can get these enforced by sending applications to the embassies concerned. And representation is something which is very important. So I think immediate representation should be sent to the embassy at the very first place.
So, Pragya, just to understand for a lot of our non-English speakers or other people, when you say a habeas corpus petition can be filed, what is the life cycle of this petition? How long does it take for people to finally see the light at the end of the tunnel? अगर कोई ये petition डालता है, उसको कितना time लगेगा अपने बच्चे को देखने के लिए, and how does this really work?
Okay, so in the most simplistic terms, habeas corpus का मतलब होता है कि आप बॉडी को प्रेजेंट करें, कोई मिसिंग है, बॉडी को प्रेजेंट किया जाए. ये हमारा कानूनी अधिकार है, मौलिक अधिकार है. This is one of our fundamental rights. So there is a hierarchy of courts. There are district courts, high courts, and there's Supreme Court. But in the interest of justice, sometimes there's a situation where it becomes difficult if a person will be directed कि पहले आप थाने जाइए, फिर आप कंप्लेन करिए, फिर आप ट्रायल कोर्ट जाइए, उसके बाद आप यहाँ पर आइए. So usually एक सीढ़ी बनी हुई है जहाँ step by step आपको चलना पड़ता है. But in situations like these, we have 5 writs that are provided by the Indian Constitution to us. तो आईने भारत में 5 ये जो writs मिली हैं, उनमें से एक है habeas corpus, जिसमें इंसान सीधे हाई कोर्ट जा सकता है या सीधे समटाइम्स सुप्रीम कोर्ट भी जा सकता है. हाउएवर ये आपसे बोला जाता है कि आप पहले हाई कोर्ट जाइए, वहां पे आप कोर्ट के सामने पेटिशन डालते हैं और आप वहां पे बताते हैं कि ऐसे ऐसे इंसान मिसिंग है और इसको मुझे प्रोवाइड किया जाए. यदि आपको उस इंसान के वेयर अबाउट्स नहीं पता है तो आप मैंडमस के डायरेक्शन डाल सकते हैं, मैंडमस की रिट फाइल कर सकते हैं. बट इन केस you are aware that the kid is missing or the child is missing and I believe that the child is with this person, then you have to file a petition for habeas corpus. So in that scenario, I don't know how correct it would be to say कि कितने कम समय में conclude हो जाएगी, but usually writs are listed up within 2 to 3 days. तो आज यदि आपने फाइलिंग की है 2 से 3 दिन वर्किंग डेज के अंदर मैटर यूजुअली टेकअप हो जाता है. नोटिस अगर कोर्ट को जेन्युइनली लगता है कि यहाँ पे स्ट्रॉन्ग रीजंस हैं, तो वो विद इन आई थिंक 2 से 3 डेट्स के अंदर वो कर देंगे. इफ लमसम अगर आपको देखा जाए तो मुझे लगता है रिट्स में 4 to 5 वर्किंग मंथ्स में कुछ ना कुछ एक ऑर्डर आ जाता है, भले वो एक इंटरिम ऑर्डर ही क्यों ना हो. एंड देन इट इज ओपन टू द पार्टीज वेदर दे वांट टू चैलेंज. बट देन अगेन सेइंग, ये केविएट है कि ये कहना बहुत मुश्किल होगा कि हिबिस कॉर्पस की पिटिशंस सिर्फ 5 महीने में या 6 महीने में ही कंक्लूड हो जाती हैं, ये 1 साल लगता है. बट ऑन एन एवरेज 6 मंथ्स का ड्यूरेशन मैं कह सकती हूँ. बाकी जैन सर, इफ यू हैव समथिंग टू ऐड, या मेघना मैम प्लीज करेक्ट मी इफ आई एम रॉन्ग.
Coming to Jayant, first Jayant, anything else you'd like to add in terms of international matters? Sorry, and otherwise, yeah.
So what Pragya has already covered, I think, is the right mandate for habeas corpus. It around take about 6 months on a a conservative side. Normally, writs are also expedited early because in a habeas corpus, the police is also involved in terms. Let's say if you're not only, let's say the child has been taken away, that is one scenario. But also if the parent, despite repetitive efforts, is not being able to meet the child or being threatened, be it a mother or a father, then obviously first thing before you file a habeas corpus is to go to a concerned police station in your area and file a report of a missing person if you do not know, because sometimes what parents do, they go and go underground, so we do not know the actual whereabouts of a child. They may have traveled boundaries within the country or international boundaries. That may also happen. I am filing a lot of habeas corpus across the country for multiple clients, both local and international. So that becomes a problem sometimes in identifying. So the first pit stop for a habeas corpus is go to your local police station, because a police report is normally sought by the judges also when you're filing a habeas corpus, and a police help and assistance is also taken by the courts in identifying the whereabouts or the phone call location or call detail records, etc. All those things are taken place. Normally, if it's a case of within India, let's say, so maybe a month or two, a short date is given, because the mandate of any writ petition in High Court under Article 226 or 32 of for the Constitution, the idea is to quickly dispose them off. So I'm not saying all the parents should or all the fighting parties should resort to habeas corpus should the need not arise. But if you do not know about the whereabouts of a children or a child, habeas corpus is definitely a sure method to go and along read with the writ of mandamus, as Pragya ji has already rightly pointed out.
Thank you, Jayant. Coming to Meghna, there's also another question. If you could take that up alongside any other additional points that you'd like to make here. What is your opinion on false POCSO cases being filed against the non-custodial parent, again to sabotage the child's rights? Sorry, Meghna, requesting you to unmute, please.
Am I audible now?
Yeah.
Sorry, I can't see in the question.
So this is in the Q&A open section by Zian Lakarwala. This is about the 4th, 5th question there.
Okay, so false cases being filed. So first of all, one point that I think I think Deepika made, which I think is something which, while we are discussing, yes, the legal remedies and the legal system, essentially what happens is that in cases where children are involved, and this, across and all parents, this is a plea to all parents who are embroiled in these disputes and their families, to not misuse law in these ways, whether it's a cruelty dowry, whether false rape cases or a false POSCO complaint. All of this is just complete rampant misuse, which, if welfare of the child is what is paramount as per law, and that is the endeavor of our system as legal practitioners or as judges, women who misuse dowry complaints, for example, and false complaints which have been deprecated by the Supreme Court so strongly. Now, any such acts which are done, they just pull the entire system, which is anyways crumbling because of the pressure. It just delays it. And you see what has happened now, women have misused it, and it just delays. And now now when you file a complaint, for example, an inquiry needs to be done before any action will be taken. There's no presumption. So you, as a woman, and as a practicing lawyer, I always feel, and my advice always is, do not indulge in this. And I know there are lawyers who advise that file this case, build the pressure, file a CAW
It's
complaint,
almost like
file
a
a POSCO
package deal.
complaint. Yeah, like a package.
Usko
Yeah,
say,
this, and you have to see what are the facts of your case. And many times, and Ashima, I wanted to bring this to the table, that my experience of pre-mediation conciliation through the High Court has been fantastic. Parties who are not otherwise willing to just speak to each other, visitation has been uh, allowed, has been brought forth. Parties have started talking. Maybe you don't move immediately to a situation where parties are filing divorce by mutual consent, but where parties were not willing to allow the child, or were using the child as a pawn. And this POSCO complaint, for example, which is false, that is also just one of these tactics, which I really frown upon, because uh, every time you do this, you just it's misuse. So and as anyone who does this, courts need to come down very, very strongly. And I know Deepika is doing a lot of work on this, so maybe she wants to add, but ultimately, uh, as people who form part of the system, we all as lawyers also must stop this. And we should not look at just one case, because you just fail the entire system ultimately.
true. Thank you.
I just want to add small little thing over there. I have been in the space of dealing with people who have been falsely accused and dealing with the system while they were innocent for a long time. But two things that have impacted me personally a lot, and I just am in awe of how low can a human being drop, is false POXO cases and false rape cases. I mean, dowry cases, domestic violence cases, I could still see it as, ठीक है, revenge में सब चलता है. वो बोलते हैं ना कि किसी से बदला लेना है तो आप कुछ भी कर सकते हो. But false rape case and false POXO case, rape and sexual abuse is so detrimental to any human being. To make a mockery of it by claiming that it happened with you when it did not happen is so obnoxious. Right now, and it just boggles my mind, sometimes. An educated teacher has an educated doctor sister of hers making a fake medical complaint of a 6-year-old kid to implicate the husband, who she has already separated since last 3-4 years. And then suddenly this POXO case gets created, And I think sometimes the investigating agencies also have to put some brains. I understand doing an FIR is must, and it must be, the norm that FIR should be filed. But what about investigation? I mean, you need to do some sort of investigation. Thankfully, this person has now been able to get the, system moving a little bit by filing applications in the home ministry, in the medical department. It came out that the medical record did not have any entry in the records over there, and this doctor fabricated it, and now there's an inquiry set up. But that happens in rare cases. So I don't know what to do, but I think as hard as the courts really need to come down on rapists, people who sexually abuse anybody, as harsh the punishment of those crime base, I'm sorry to say, I have not seen the same zest in the judiciary to punish people who file false cases. And I think we are only breaking down our own system. And I think we are only doing not just wrong to the innocent men who are falsely implicated like this, and a lot of women also nowadays, but you are doing greater harm to genuine victims, or women, girls, boys who are victims of rape, sexual abuse, sexual assault. I have made India's sons only because it took 30 years or more for the misuse of 498A to be taken seriously.
Yeah.
I do not want that something as serious as false rape cases to go through that longer process. I do not want our Supreme Court to someday say that, do not immediately arrest, because a lot of rape complaints are now turning out to be false. That should not happen. That would be so wrong. So Zian, to answer your question, Just my last submission, there are now a lot of false POXO cases happening in custody battles. I am aware of those. If 4 or 5 parents can get together and approach the Supreme Court, that this is now becoming, one more tool in the hands of people to be abused and seek for some guidelines, I think that's the only solution that we could probably have.
Thank you, Deepika, on sharing that solution. But we also have a host of other questions to go. So if I may request our panelists to spare some more time, say another 15-20 minutes, we'll quickly go through the Q&A and then come back for closing remarks. If
Ashima,
that's
there's
okay.
a question that in fact, I'm reading it since so long, and I feel the pain of this woman who's asked this, and this sort of emphasizes that actually, Pragya, this is absolutely not a gender issue. I understand it happens to all, but I would like to believe that a little overwhelming majority of people not getting access to their kids are fathers. But here's a question from Veena, and she says, Madam, I have not been allowed to see my 12-year-old since last 3 years. Until now, court has not taken any step against the respondent. What can I do? If somebody could answer her legally.
Yeah, Deepika, I was just coming to that we'll request our panelists to, spare some time. Pragya, sorry.
Ashima, I've typed answers to 4 of the questions, and I think I'm going to type the answer for the legal questions. So I've given answers to 4 of them, and I try to give answers to as much.
Thank you, Pragya. So I was just hoping that we would quickly just take all the questions. I'll just read them out. Then one by one, we'll come back instead of like coming after one question and answer. Let me just take a holistic view of this because we have too many questions and we can't go one by one. So I'll read out all the questions, and then whatever common guidelines or guidance, you all can provide, that'd be great. So there's another question. So we've heard about the international false cases, of course. Then there is a question on, if a wife is highly qualified and postgraduate, she's working before marriage and now she's not working, and asking about 70% of maintenance from the husband. Please suggest, what can be done here. If the women or the mothers are qualified enough to maintain their children on their own. That's one sort of a common question I see. There's another one on how are we supposed to build a bond with our children for a few hours in a month? Isn't it unfair to the children? Parental alienation is an emotional act of violence that is aimed at an adult, but critically wounds a child. That's, of course, the sentiments of parents coming through. Then we also have questions on any inputs from the government and the Ministry of Child and Welfare. What can they do about some of these things? Then there's also one question on men who have asked wives to abort the child and even had the audacity to say he would need the DNA test to verify if it is his child. So is such a person really worth having access to child when he never belonged or was not ever emotionally or financially available? So that's a case of an absentee father. Then we have, several questions on international perspective we've taken, misusing of laws we've taken. So, some of these questions are repetitive, but we'll try to take some of these holistic view on when people haven't met their children for 2 to 3 years, when there is misuse of laws, and reverse maintenance. So, if a mother can maintain the child instead of the father. So let's hear it from Jayant first.
Right, Ashima. So a bunch of questions, and as the panelists already pointed out, and we as lawyers, at least me, Meghna ji, and Pragya ji together, everything is fact-based, and that's why we said fact are so crucial to any case. And you have put 5-6 different questions, and I can give you 15-20 different answers. For that, I'll have to go through them individually. But to sum it up, if there has been a delay for any parent in meeting their child, there are always 2 options. You can either get the judge changed or the lawyer changed. You're always free. You are not a tree. I always tell people, आप अपने वकील से कुछ नहीं है, वकील बदलिए. जज से खुश नहीं है, आप जज की ट्रांसफ़र की भी अर्जी डाल सकते हैं कोर्ट में। ये सारी प्रक्रिया कानून में आपको दी गई है, सारे प्रावधान दिए गए हैं। सो दैट इज़ वेरी इंपॉर्टेंट फॉर द नॉर्मल पर्सन, जो ले पर्सन जो इसको सुन रहे हैं, इस चीज़ को समझे। क्योंकि कानून में ये बात देखी जाती है कि कई बार हो सकता है कि आपको एक निष्पक्ष मत ना मिल पा रहा हो किसी कोर्ट से, या आपके वकील साहब हो सकता है कि आपके साथ ज़्यादा समर्थन ना दे रहे हो, वकील साहब या साहिबा जो भी हैं, तो आप उनको भी बदल सकते हैं। तो ये कानून में सारी चीज़ें, अगर 3 साल हो गए आपको अपने बच्चों से मिले हुए, तो आप एक अर्ली हियरिंग की एप्लीकेशन डालिए और कोर्ट के सामने ये बात अपनी रखिए कि भाई मुझे 3 साल हो गए, 3 साल इज़ टू लॉन्ग अ टाइम इन एनीबॉडीज लाइफ स्पैन, कि भाई इतना लंबा ड्यूरेशन कैसे हो गया, वाई इज़ द कोर्ट एडजर्निंग अ मैटर, इज़ दैट नॉन एप्लीकेशन ऑफ माइंड। उसमें आप हाई कोर्ट जा सकते हैं मैंडेमस के रेट में, जैसे कि प्रज्ञा जी ने बोला, टू एक्सपेडाइट अ मैटर, क्योंकि रेट्स हमेशा एक क्विकर सॉल्यूशंस होती हैं इन चीज़ों के लिए। तो दैट्स वाई इट्स इंपॉर्टेंट टू हैव अ गुड एंड अ एजुकेटेड लीगल टीम विच कैन गाइड यू इन द राइट डायरेक्शन। इसलिए मैंने आपसे शुरू में कहा था कि वकीलों को ब्लेम करना बड़ा आसान होता है कि वकील ऐसी बात कर रहे हैं, ये कर रहे हैं। कहते हैं ना कि जब एक उंगली आप किसी इंसान पर उठाते हो, 3 उंगली आपकी तरफ भी होती हैं। तो अगर आपको लगता है कि सिस्टम में कुछ खराबियां हैं, कुछ कमियां हैं, तो सिस्टम मैं और आप ही हैं, कोई तीसरा इंसान नहीं है जो सिस्टम बनाता है। सिस्टम को बदलने के लिए आपको भी पहल करनी पड़ेगी। तो अगर वकील से खुश नहीं है, वकील बदलिए। जज से भी खुश नहीं है तो आप जजेस को भी चेंज कर सकते हैं। दोनों आपके पास पहलू मौजूद हैं इसमें। कस्टडी की आपने एक बात की, आशिमा, और क्या आपके 2-3 सवाल थे?
कि रिवर्स मेंटेनेंस, लाइक इफ द मदर कैन मेंटेन द चाइल्ड, तो क्या फादर पे रिस्पॉन्सिबिलिटी आनी चाहिए, और अगर किसी के ऊपर ये रिस्पॉन्सिबिलिटी है एंड वो उसको पूरा नहीं करते, तो देयर इज अ क्वेश्चन ऑन दैट, समबडी फ्लाउट्स द ऑर्डर,
जी
द कमिटमेंट्स आर ब्रोकन, तो क्या करें?
हाँ, तो देखिए इस पे एटलीस्ट मैं आपको दिल्ली के अंदर का सिनेरियो बताता हूँ कि क्या हो रहा है, और ये देश भर में कई जगह और हाई कोर्ट ने भी लागू कर दिया है कि अब जो भी पार्टीज मैट्रिमोनी में लड़ाई करती हैं, उनसे उनके पिछले 3 साल का बयाना मांगा जाता है। मतलब कि 3 साल की इनकम टैक्स रिटर्न और बैंक स्टेटमेंट मांगे जाते हैं, ताकि कोई भी पार्टी 19-20 ना करे कोर्ट में। तो जो कागजी जो एविडेंस है, जो सबूत कोर्ट मांगता है, वो इसलिए ताकि आपका इन 3 सालों में आप कहाँ पे एम्प्लॉयड थे, आपका बिजनेस था कि नहीं था, आपने टैक्स रिटर्न भरे कि नहीं भरे, अगर टैक्स आप नहीं भरते हैं तो आपके 3 साल के बैंक स्टेटमेंट कितने थे। अगर आप कोई बैंक स्टेटमेंट कंसील करते हैं, कोई डॉक्यूमेंट कंसील करते हैं, तो बाकायदा कोर्ट उस पर हरकत में आएगा, आपके ऊपर कंटेम्प्ट हो सकती है, आपको जेल भी भेजा जा सकता है। मैं आपको अपने एक क्लाइंट का उदाहरण यहाँ देना चाहता हूँ, जिनकी जब शादी हुई तो उनकी वाइफ उनसे तकरीबन 15 साल बड़ी थी उम्र में, और उनकी जो इनकम थी अपनी वाइफ से कम 1/4 थी। और उनकी वाइफ ने डोमेस्टिक वायलेंस और मेंटेनेंस केस में दावा डाला कोर्ट में कि भाई इनको बोलिए कि मुझे मेंटेन किया जाए, और हमने उस चीज़ को अपोज किया। और कोर्ट में, बाकायदा फैमिली कोर्ट में और महिला कोर्ट में, हम लोगों को ये रिलीफ मिला हस्बैंड के लिए उस दिन, कि जो आदमी, मान लीजिए मेरे अगर क्लाइंट उस टाइम 15,000 रुपये कमा रहे हो, तो उनकी जो मिसेस थी वो 1.5 लाख रुपये कमा रही थी। तो कोर्ट ने भी इस बात को मद्देनजर रखते हुए कहा कि ऐसा हम कैसे कर सकते हैं, दिस इज़ इनजस्टिस। तो उनको वेरी स्ट्रिक्ट वार्निंग वाज गिवन टू द लेडी एंड हर पिटीशन वाज डिसमिस्ड। देन शी ऑल्सो अपील टू द सेशंस कोर्ट कि ये डिसमिस किया, सेशंस कोर्ट में भी हमने अपोज किया और उनको वापस से उनका डिसमिस हुआ मैटर। तो ऐसी बात नहीं कि जजेस आर नॉट वेरी ऑफ द मैटर, जजेस आर वेरी वेल अवेयर कि आप क्या पॉलिटिक्स खेल रहे हैं कोर्ट में और आप क्या तकनीक अपना रहे हैं। क्योंकि जैसा मैंने आपको अपने ओपनिंग कमेंट्स में भी कहा कि एक जज के सामने ये डेली मैटर्स हैं 50-100 जो आते हैं, उनको पता है पार्टी क्या क्या टैक्टिक्स डिप्लॉय करेंगी या वकील साहब की क्या स्ट्रैटेजी होगी, उनको सब पता है। आप ये समझिए जो आज इंसान जज बन के बैठा हो पहले वकील ही था, है ना, और वकील होने से पहले वो एक आम इंसान है। तो जो चीज़ें हम कोर्ट में देख रहे हैं, जो सोसाइटी की हम छवि कोर्ट में देखते हैं, ये सारी चीज़ें जज करके निकल के वो जज बने हैं, है ना। वकील से जो इंसान जज बना है तो उसको ज़्यादा समझ होगी दुनियादारी की। तो ये जो सारी चीज़ें हैं, यही मैंने बोला, अगर आप नहीं खुश हैं अपने वकीलों से या जजेस से, तो कानून में पूरे प्रावधान है आपके लिए, आप उनको चेंज करें। अगर आप समझते हैं कि जज साहब की कोई गलती नहीं है इसमें, वकील साहब की गलती नहीं है, अर्ली हियरिंग एप्लीकेशन लगाएं। और जहाँ तक मेंटेनेंस की बात मैंने आपको भी बताई कि अगर आपकी इनकम कम है बतौर हस्बैंड अपनी वाइफ से, तो ये भी आप अपने डॉक्यूमेंट्स के थ्रू कोर्ट को बता सकते हैं। और कोर्ट्स, सुप्रीम कोर्ट तक अब ये बात कह चुका है हमारे देश में कि अगर दोनों महिला और पुरुष अर्निंग मेंबर्स हैं, एजुकेटेड हैं, फाइनेंशियली इंडिपेंडेंट हैं, तो कोर्ट कई बार उनको वो मुआवजा या वो मेंटेनेंस नहीं देता। स्पेशली जिन केस में बच्चे नहीं हैं, उनमें तो कोई परेशानी नहीं है। जहाँ पे बच्चे हैं तो कोर्ट ये दखलंदाजी करता है कि क्योंकि आप पेरेंट हैं, आप माँ हैं, आप बाप हैं, आपका बच्चा है अपना, तो उसके लिए बराबर की हिस्सेदारी हो। और बराबर की हिस्सेदारी मतलब हो सकता है आपको 1/3 आपका जो पेमेंट है, मान लीजिए आप 20,000 रुपये कमाते हैं, तो 1/3 आप कम से कम बच्चे की उसके लिए दीजिए। हस्बैंड को भी डायरेक्शन दिए जा सकते हैं, मदर को भी डायरेक्शन दिए जा सकते हैं। और बाकायदा जो खर्चे होते हैं बच्चे पे, मान लीजिए अगर 4 साल का बच्चा है, मैं आपको एक इलस्ट्रेशन दे रहा हूँ, जो कि प्ले स्कूल जाता है या जो अपनी अभी एजुकेशन शुरू कर रहा है, उसके खर्चे कम होंगे लाइफ में। हो सकता है कि जो लैक्टेटिंग चाइल्ड है उसके लिए आपको डाइपर्स खरीदने हैं, मिल्क पाउडर खरीदना है, बाकी चीज़ें जो हो सकती हैं, वाइप्स वगैरह हो, तो उसकी एजुकेशन की जिम्मेदारी नहीं होती। पर अगर बच्चे बड़े हैं, मान लीजिए टीनेजर्स की हम यहाँ पे बात कर रहे हैं, जो कि यूनिवर्सिटी जाने वाले हैं या जिनकी हायर एजुकेशन हो रही है, तो उनकी एजुकेशन महंगी होगी, जाहिर सी बात है। अगर आप प्राइवेट स्कूल में पढ़ रहे हैं, आपके कम्यूट्स की जो रसीदें होती हैं बस की, ये सारी चीज़ें कोर्ट आपसे मांगता है कि आप दिखाइए कि आप कितना खर्चा कर रहे हैं। अगर पेरेंट के पास, मतलब फादर के पास बच्चा है, तो फादर से रसीदें मांगी जाती हैं, मदर के पास बच्चा है तो मदर से रसीदें मांगी जाती हैं। तो कोर्ट में जो जो ट्रायल की प्रक्रिया होती है, ट्रायल क्यों होता है? ट्रायल इसलिए कंडक्ट किया जाता है देश में कि सच और झूठ का पर्दाफाश हो सके, इसलिए पूरी ट्रायल की प्रक्रिया होती है। इसलिए हमारा जो, और कानून आज के नहीं बने हुए हैं, ये कानून सालों से चले आ रहे हैं। बीइंग अ लॉयर इज वन ऑफ द ओल्डेस्ट प्रोफेशंस इन ह्यूमन सिविलाइजेशन। तो ये कानून, ये जो विजडम है हमारी जुडिशरी का, ये आज का नहीं है, 2021 का नहीं है, ये 2000 या 20 साल पुराना है। तो इसको आप समझिए कि कैसे हो सकता है। और कानून मैंने बताया जैसे कि आप सभी के लिए हैं, लोग आप सबके लिए हम लोग काम करते हैं, जजेस हैं, जुडिशरी है, लॉयर्स है, वी आर नॉट अगेंस्ट यू, वी आर फॉर यू, बट फॉर यू टू अंडरस्टैंड दैट, फॉर यू टू take advantage of the laws which have been framed by the parliament and which are being interpreted and implemented by the courts, you have also to come to terms what are the facts of your case. इसलिए मैंने कहा फैक्ट से ऊपर बढ़ के कोर्ट में कुछ नहीं होता, तो हर केस का फैक्ट अलग है।
There's an
Ashima, मैं एक बहुत sorry, please go ahead.
There's an associated question. Mohit Wadhwa ji ने जो पूछा था, in case wife is highly qualified, postgraduate, she is working before marriage and now she's not working and asking about 70% of my salary. So you see, a lot of things are said and done in the court, but it doesn't matter. Law is settled. It is categorically mentioned in section 60 of CPC that not more than 1/3 of the salary of the husband can be executed. It can not more than 1/3 can be attached. तो आप बोलने के लिए अगर जो है लाख रुपए पति कमा रहे हैं तो आप बोल सकते हैं कि मुझे 90,000 चाहिए, बट इट डजंट मीन कि जज आपको 90,000, वो पहले हो सकता है एड इंटरिम ऑर्डर पास करेगा, फिर वो इंटरिम ऑर्डर पास करेगा। ओवर द पीरियड ऑफ टाइम ये फैमिली लॉ के जूरिस्प्रूडेंस बहुत अच्छे से इवॉल्व हुए हैं। लाइक जैन सर सेड, ये 3 साल का जो ITR रिटर्न्स का पैरामीटर है, दिस इज वेरी गुड। ये दूध का दूध पानी का पानी कर देता है कि दोनों हस्बैंड वाइफ के क्या कोई जॉइंट अकाउंट्स हैं, हाउ मच मनी आर दे गेटिंग, क्या ये अपने टैक्स रिटर्न्स पे कर रहे हैं, इनके कॉमन ATMs हैं, क्या जॉइंट असेट्स हैं, क्या लाइबिलिटीज हैं। अगेन देयर इज अ लैंडमार्क जजमेंट जो आया था कुसुम शर्मा के केस में, जिसमें फॉर द फर्स्ट टाइम एक बहुत ही डिस्क्रिप्टिव और एग्जॉस्टिव मेंटेनेंस का एफिडेविट फॉर्म होता है जो आपको फिल करना पड़ता है। सो बिफोर यू फाइलिंग अ पिटिशन, इट्स अ वेरी एग्जॉस्टिव पिटिशन जहां पे आपको एक एक चीज मेंशन करनी पड़ती है कि आप ये पैसा क्यों क्लेम कर रहे हैं, किस किस हक से मांग रहे हैं, डू यू जेन्युइनली थिंक इतना होना चाहिए। तो अगर आप अपने इंटरनेट चार्जेस 1500 रुपए बता रहे हैं, और ऐसे भी लोग हैं जो अपने अपने बच्चे के जो है साल के खर्चे जो है 5 लाख रुपए बताते हैं, जहां हस्बैंड शायद ऐसा नहीं कमा रहा है या वाइफ नहीं कमा रही है, तो कोर्ट बैलेंस चेक करता है, दोनों की हिसाब हैसियत चेक करता है और उसके हिसाब से ही फिर वो एक वर्डिक्ट पास करता है। सो दैट्स द थिंग।
मेरा बहुत छोटा सा क्वेश्चन है जय जी और प्रज्ञा जी अगर आंसर कर दे, बट क्योंकि ऐसा केस मेरे पास आया था इसलिए मैं पूछ रही हूँ। जब विजिटेशन ऑर्डर्स अगर ऑनलाइन पास हुए हुए हो, फादर को मिले हुए हैं विजिटेशन ऑर्डर्स, तो क्या वो जो विजिटेशन है, जब वो ऑनलाइन बात कर रहे हैं अपने बच्चे से, क्या वो रिकॉर्ड करी जा सकती है? क्योंकि इस केस में क्या हुआ, उनके पास ऑनलाइन विजिटेशन थी और उसके बाद वाइफ ने फिर उनके ऊपर एक और क्रिमिनल केस फाइल कर दिया कि ये ऑनलाइन जो विजिटेशन थी तब ये बहुत ही ऐसे सेक्सुअल एक्सप्लिसिट इन्होंने बातें करी और ये सब वो सब करके, और एक और FIR उनके ऊपर डाल दी, तो वो उनकी विजिटेशन भी खत्म हो गई। तो क्या ये चीजें, क्या ये विजिटेशन रिकॉर्ड कर सकते हैं कोई भी अगर नॉन कस्टोडियल पेरेंट?
Okay, sorry, I know there's paucity of time at your end. If you'd like to take this up, that's fine. Or if we can also request some of our other panelists to take it up.
I think Jayan sir and Meghna ma'am can answer this.
Sure, Pragya.
Thank you. Sorry, I'll have to take your leave. Thank you so much.
Thank you so much for joining us today, Pragya. Thank you so much. So wonderful having you.
Sure.
So coming to Meghna and carrying on the conversation, Meghna, if you could take up Deepika's question.
Sorry, I'm having some. Deepika, can you please repeat your question? Sorry, I'm having some.
Deepika, requesting you to unmute.
Can the non-custodial parent who has a visitation online record those visits?
So, see, recording is something that you need permission before you can record. But Deepika, that said, you see, when people do record, and these days on smartphones, even audio conversations are recorded, it does, and things get filed. The judges at the end of the day also, and this also applies to when we have a discussion on media trial, when you read. So it does impact, and it may not be admissible under Evidence Act as such, and you can take all of those objections. But if the judge has read the contents, and many a times also WhatsApp conversations are printed, you see, so as Jayant was saying, ultimately it may be a question for trial to decide whether it would be admissible or not, but it does impact on interim reliefs that you get, on visitation that you may or may not get. And the judge may get a sense that it's an inappropriate behavior. And for example, if you're saying that the content of the conversation was inappropriate, so the judge
No,
is
no, it was not inappropriate. It was done by the mother to cancel the visitation. She just gone ahead. She went ahead and
so
filed.
that depends, and that can
Yeah.
always be brought out, you see, in the court. But it will
So-
be something that will ultimately, whether that in your case, whether it will be admissible, will be something that you can fight in the trial stage. But it
what you're
does.
saying is, if a person has an apprehension that he would, or he or she would want to safeguard themselves from something like that happening, they can request the court that if these interaction can be recorded, right? So that nobody is able to falsely
Yes,
accuse
courts do. Yes, and like I mentioned, at this stage where we are online or dealing with virtual interactions, but where it's required, courts premises themselves have now rooms, which are very nice, colorful rooms where children can come and sit, where there are swings, there are you can come and spend time with your child there. So
Thank you, Meghna.
yeah, I'm sorry, I also just need to run, Ashima.
I was just coming to that. I think we have too many questions, and we've already spent a lot of time here. Thank you so much, panelists, for joining us. Meghna, if you have 5 more minutes, I would just like to wrap this. Thank you so much. Thank you so much, panelists. There's also just one more question that I'd like to take your closing remarks on. We're hearing from our attendees that there is character assassination by the non-custodial parent of the other parent, just to win back or to kind of alienate the other parent, and to take away the visitation rights. So both men and women have sent me messages saying the father will say the mother is in an adulterous relationship. The mother is saying that the father and daughter interactions are not, how it should be. So it seems like a pattern here. These things, there are false accusations just so as to keep your child to yourself. In these cases, what other reforms we can look at? Very quickly, Dr. Kapoor, coming to you, there's a question to you, what you and your organization are all about, and how do you tackle these situations? If you can answer that, and we will do a quick round before we close this discussion.
Wonderful. So if you don't mind, I'll just club both the things together, do my closing remarks and this thing together, right? So I think I'll take just a minute to say, there was a time in the 70s, 60s, 70s when we used to brush domestic violence under the carpet. Let's not talk about it. Unfortunately, we are doing the same with child custody issues today and trying to paint a rosy picture, which is going to come back to haunt us very soon, number one. Number two, I think when it comes to the law about child custody and such disputes, it can be summarized in 8 words: best interests and welfare of the child, right? That's all the law is. But unfortunate part is that there is no institutional understanding of what is best interests and welfare of the child in separated parents, right? Now, fortunately, science and research has made it extremely clear. Now it's conclusive. We have study on more than 2.5 lakh children over 14 countries, spread over 40 years, 200 of the world's best psychiatrists and everybody, right? So if you would see, this would also answer. So what we are trying to do is you can log on to our YouTube channel, which is Bamboo Tree Children's Foundation. You'll see what we are putting in these efforts. And now if you would see the recent interview that we did with Dr. Nielsen. So what are the reforms that need to be done? Let me just put it down: 1, 2, 3. Number one, a rebuttable presumption of shared parenting, and shared parenting is clearly defined as 35% of the time with either parent has to be put in. That is the truth all across the world. And it doesn't matter whether the parents are in high conflict, the parents are have different parenting styles, the parents could be in any geographies, doesn't matter. That has been clearly. So number one. Secondly, I think the Family Courts Act 1984 was a beautifully drafted act which gave a lot of powers to the so the Family Courts Act did give a lot of powers to the courts. Unfortunately, the courts are not utilizing them. So they must do two things. Number one, the Supreme Court must frame these guidelines to say rebuttable presumption of shared parenting needs to be put in together with compulsory submission of parenting plan. Number two, Section 12 of the Family Courts Act clearly specifies that child psychologists and social workers need to be attached. A body like what is there, CAFCAS in UK, needs to be instituted in our family court, which is an independent body of child psychologists, because at the end of the day, a child's best interests and welfare is at the interface of science and law. There is less of law, more of child psychology and child development, which needs to be taken care of. Therefore, a body like that needs to be created within the family court system. So these are the two immediate reforms which can be done without any delay.
Thank you, Dr. Kapoor. Jayant, your inputs on that. You've already mentioned we need more funding and the judge to population ratio needs to improve. Anything else you'd like to add to it?
Look, I can only request the parties to not fight, but I don't think that's going to happen. Parties will still fight, and that's why the lawyers are needed. We don't make people fight, but they fight. So I can't tell people not to marry, they will marry. I can't tell people not to divorce, they will divorce. So, so the net is, please have faith in the system. It's not, all the doom and gloom as you make it out to be. There is always, as we say, light at the end of the tunnel. That is number one. Second, yes, delay. We are all suffering equally because of delay. As I said, I have not done trial in 1.5 years of my practice because of the pandemic. It is something worrisome. The courts have taken cognizance of these things. We are moving in the right directions, but COVID is something which has really, taken us a few years back. At the same time, we have also embraced virtual court hearings, which have expedited the matter, in which I think parents sitting in any corner of the world, in any part of the city, tier 1, tier 2, now they have the access to justice. They can just click on the button, see if their lawyers are arguing properly, see if the matter is being heard online. So we have also made progress. Yes, it's a long drawn battle. I think some of the suggestions put by Dr. Kapoor are also wonderful, which I think must be taken on board by the family court. Some of the suggestions by Deepika ji are also very nice in terms of gender neutrality and how things needs to go forward in more consonance. But as we all the lawyers said together, everything is fact based, so we have to also take care of the facts which come in question before a particular case. But all said and done, I do wish all the panelists and the viewers a good health during these pandemic times, and let's hope that we keep our near and dears in good mental and physical health.
Thank you so much. And Meghna, coming to you also, if you could shed light on free legal aid for those who cannot engage lawyers, high profile lawyers for their matters.
You don't need a high profile lawyer, number one. Any lawyer who's genuinely interested and wants to help is good enough. As Janji rightly said, if you're disappointed with a lawyer, there are lots of other lawyers who are out there. But if you do need to approach, there are legal aid cells in every district court as well as the high court. And also lawyers are flexible on fees. They are, if there are genuine cases of people who can't afford your full fee, we all do it all the time and, help out. So, of course, legal aid facility is there, and good lawyers, youngsters, as well as seasoned lawyers are all registered
and also
there.
So, mediation. So if you're looking at, outside court settlement, how can they approach that route?
So all you need to do is file an application, and it could either be a joint application for conciliation, which is a pre-litigation, or a pre-litigation mediation, either of which I normally prefer the conciliation route, because that ends up in an award which you can then take forward like a decree. So and it costs about 21,000 for the Delhi High Court. I'm not aware at the district court level what it the charges are, but we have very, very good trained mediators and conciliators who are genuinely interested in the welfare of the parties, who act as the branch between the two. And again, I think Jen really summed it up, that what we do need is probably more resources, perhaps guidelines, as Dr. Kapoor said. And I was not aware of the impact, frankly, and some of the numbers that he shared. Those were eye openers for me. So I think if all of us work together, so I think the lawyers are there, the statute provides it, but some of the things can be added. Definitely, because of the population and the numbers increasing, we need to augment judge strength, and perhaps more training of counselors' involvement, etc. Perhaps if the judges are very busy, if every family court were to have more counselors who could interact with the children in a more detailed manner, and if 15 minutes is not enough, and time to come to a conclusion, although in my experience judges spend more time than that. But that said, I'm not someone who's in a family court every day. So things can be done, and if we brainstorm together, we could come to various solutions. And just framing of guidelines, to my mind, may not be the solution. We need to ultimately act on these things. So we increase judge strength, we have more counselors involved, we do more mediation, then one can hope for more solutions to come forward. And legal aid, of course, is there for since many years.
Yeah, absolutely. Thank you so much, Meghna. Deepika, coming to you for any closing remarks. Unmute, please, Deepika.
What I'm going to propose is, I think, going to be a little, too big to happen, but I earnestly want that to happen. I think there's a dire need that the Women and Child Development Ministry gets separated. We definitely need a separate ministry for children now. They form a huge population in India. And it's not just about their, taking care of kids who are poor and their needs and in Anganwadis and all of that. I think women's issues are very separate. Children's issues are very separate. We need a dedicated ministry, especially for these new age problems that kids may have, and having more counselors and having more opportunities for them to approach for their problems. I could count them, n number of them on my fingers. There's drugs problem. There is juvenile justice homes that are in absolute tatters. I read I think a very, very detailed report by one of the news organizations. I don't remember the name, sorry, but it was a brilliant report analyzing 6 juvenile homes in Delhi, and the kind of, miserable condition these juvenile homes are. It's very sad. So I think our ministry really needs to look at that. I don't know what's the bifurcation of funds for women's issues and children's issues in the WCD ministry, but I would certainly want a lot of people to focus on children's issues because they are the future of a country. Second thing I think I would want to happen, which does not happen, is that NCPCR can probably play some role in these marital disputes as well, because this is not a court system, So if they can probably come into the picture of at least speaking to these parents in disputes so that they don't have to land up in the court, and some mechanism, because I know personally a lot of people have approached NCPCR when they're facing visitation issues, when they're facing delays and all of that, but they say, you're in the court, we can't do anything about it. But maybe they could have some mechanism to deal with these problems, at least have a conversation with them or have some mechanism to deal with them, because they're also working for the welfare and best interest of the child.
Yeah.
And last but not the least, like we would all want, I think it doesn't take too much to be a better human being. So we can all hate somebody, we can all hate our spouses, our partners, a friend, or anybody, but let's keep kids out of these adult issues and ego battles. They get scarred, and they get scarred that we don't even know. Just put yourself in that shoe and think if your childhood would have been like that. I have seen videos where parents are hitting each other and the child is there. I've spoken to some of these kids. It's heartbreaking. It's just very heartbreaking. You spoil them for their lives. and they're never
Yeah.
able to come out of it. It's a very serious issue.
Yes, absolutely. Thank you, Deepika. I think that's our last message to our audiences, whether you're a father or mother, male or female, please put your children before your own egos, and go for simple, non-complicated petitions. Please don't go for a package deal. If there is one problem, don't add 10 more to it. It'll only delay the proceedings. So we hope all of your questions were answered. If you have any more questions, please write into us at ashrama@businessworld.in. Thank you so much to our panelists for having spared.
I've also dropped my email there. And just one last submission. Sorry, I really wanted to say this. I forgot. Let's just, accept that people do move on. I see a lot of these egos because either the man chose the new partner or the woman chose a new partner. Arey bhaiya, let people live happily. You can also, move on in your life. You just किसी और की जिंदगी बर्बाद करके जो आइडिया होता है कि मेरा तो खराब हो गया तो तुम्हारा भी सही, that's such a negative thinking. People really need to come out of that thinking, and I think everybody can be happy if they just focus on bettering their life rather than spoiling somebody else's. Thank you so much.
Thank you, Deepika. We'll share all of your emails with our attendees, so we'll take that on us. Thank you so much, panelists, for joining us, sparing almost 2 hours on a Saturday to take this up. Thank you so much. Really grateful for your time. And what a wonderful conversation. We hope our audiences have benefited. I personally have, and we'll ensure that we take this conversation forward. Thank you so much once again.
Thank you.
Thank you.